The Judiciary Committee will come to order. Without objection, the chair is authorized to declare recesses of the committee at any time. We welcome everyone to today's hearing on lessons from the Mueller report, presidential obstruction and other crimes. I will now recognize myself for an opening statement. Just over 2 years ago, Special Counsel Robert Mueller was charged with conducting a full and thorough investigation of the Russian government's efforts to interfere in the 2016 presidential election, unquote, including an examination of, quote, any links and or coordination between the Russian government and individuals associated with the campaign of President Donald Trump, and any matters that arose or may arise directly from the investigation, close quote. He concluded in his own words, quote, Russian intelligence officers who were part of the Russian military launched a concerted attack on our political system. Those officers used sophisticated cyber techniques to hack into computers and networks used by the Clinton campaign. They stole private information and then released that information through fake online identities and through the organization WikiLeaks. We now know that the Russian government timed their operation to interfere with our election, to harm the candidacy of Secretary Clinton, and to benefit the Trump campaign. Separately, the special counsel concluded that Russian entities, quote, engaged in a social media operation where Russian citizens posed as Americans in order to interfere in the election, close quote. Using fake identities on social media platforms like Facebook and Twitter, these operatives planned rallies in favor of the president and spread lies about Secretary Clinton made to look like legitimate media. Again, these activities represent a direct attack on our democratic process. With respect to these two specific operations by the Russian government, the special counsel did not find sufficient evidence to charge Trump campaign officials with conspiracy against the United States. He did, however, document at least 171 contacts between members of the Trump campaign and transition team and the Russian government. 16 Trump campaign officials are known to have had direct communications with Russian agents. Representatives of the Trump campaign exchanged emails and phone calls and held face-to-face meetings with high-level Russian government officials, Russian oligarchs, and even some of the hackers the special counsel accused of working to sway the election. There can be no question that Congress must investigate this direct attack on our democratic process. I believe that Ranking Member Collins agrees that we must do so without delay. In a letter he sent last month, he urged the committee to call Robert Mueller to testify during the Memorial Day recess if necessary, both for the sake of transparency and, quote, for the American public to learn the full contours of the special counsel's investigation, close quote. In a letter he sent last week, the ranking member again asked us to examine, quote, the threat Russia and other nefarious actors have played and may continue to play in our elections, close quote. Over the course of the coming weeks, this committee will do just that. We will examine the effects of foreign influence on our elections. I hope that we will hear testimony from the special counsel as well. But the country cannot hope to understand the Russian government's attack on our democratic system if we do not also investigate who stood to benefit from that attack and the extent to which the Trump campaign may have welcomed it. Similarly, we cannot fully understand the special counsel's work without also discussing President Trump's repeated attempts to undermine it. In his report, the special counsel describes 10 separate incidents in which the president attempted to change the scope or direction of the investigation or to end it altogether. At one point, President Trump ordered White House counsel Don McGahn to fire the special counsel. Later, he asked McGahn to write a letter stating that the incident never happened. McGahn said he would rather resign. At different stages, he asked Attorney General Jeff Sessions to unrecuse, in quotes, himself and to step in to direct the investigation away from the president's conduct. And of course, the president's public statements about this investigation before and after the results of the Mueller report are, at best, at odds with the evidence laid out in the report itself. There can be no question that this committee must investigate this behavior as well. Today's hearing is the first in a series of hearings designed to unpack the work of the special counsel and related matters. We have a responsibility to do this work, to follow the facts where they lead, to make recommendations to the whole House as circumstances warrant, and to craft legislation that makes certain no president, Democrat or Republican, can ever act in this way again. Our witnesses today include 3 former federal prosecutors, each of whom has considerable experience weighing the kind of evidence laid out by the special counsel in his report and in his indictments of 34 individuals, including President Trump's national security advisor, his campaign manager, his deputy campaign manager, and his personal attorney. Our panel also includes Mr. John Dean, who served as White House counsel to President Nixon and who became a critical witness for prosecutors and congressional investigators attempting to respond to President Nixon's attempt to obstruct the Department of Justice and the FBI. We will rely on the expertise of these witnesses to help draw our own conclusions about the findings of the special counsel and other evidence before us today. We will do so mindful of the House rules that prevent us from making inappropriate personal references to the President, to members of this committee, and to other members of Congress. But the rules of decorum in the House of Representatives are a shield, not a sword. The rules are designed to focus the debate on the facts and the law, and can therefore help us discuss the findings of the special counsel with the seriousness they deserve. The rules are not, however, an opportunity to avoid discussing serious allegations of misconduct altogether. I know that the ranking member and I disagree on any number of topics, including on what conclusions we should draw from the facts laid out by the special counsel. For example, in his last letter, he argued that President Trump has been, quote, vindicated, unquote, by the special counsel's report. I cannot agree with that conclusion. Neither, I believe, could the special counsel, given his insistence that his report, quote, does not exonerate the president, close quote. But I also know that the ranking member and I agree on the seriousness of the attack on our elections, that we must work together to make it more difficult for any president to ignore the danger that presented itself in 2016. That work continues in this hearing room today, and it continues at the Department of Justice later this afternoon, when this committee will begin to review some of the documents that Attorney General Barr previously denied us. I am pleased that we have reached an agreement to review at least some of the evidence underlying the Mueller report, including interview notes, firsthand accounts of misconduct, and other critical evidence, and that this material will be made available without delay to members of the committee on both sides of the aisle. As a result, I see no need to resort to the criminal contempt statute to enforce our April 19th subpoena, at least for now, so long as the department upholds its end of the bargain. But our arrangement with the department does not extend to the full scope of our request for the full Mueller report and its underlying materials, including grand jury information, nor does it extend to our demand that Don McGahn, a key fact witness, testify before this committee. Our work will therefore continue tomorrow on the House floor when we consider Chairman McGovern's resolution to authorize this committee to enforce its subpoena through civil litigation. It is my expectation that as a result of this authorization, Mr. McGahn will testify before long. And between now and then, we still have an obligation to investigate the deeply troubling evidence outlined by the special counsel. Not merely the portions that implicate Russian nationals, as some have suggested, but the entire report, including the volume that lays out some of the president's troubling behavior. The committee's work is serious. We should delay it no further. We should conduct ourselves in a manner that is consistent with the rules of the House and worthy of this chamber. And even if we cannot agree to draw the same conclusions from the evidence, we should at least proceed with a common understanding. We were attacked. We were attacked by a foreign adversary. President Trump's campaign took full advantage of the attack when it came. The descriptions of obstruction of justice in Volume 2 go to the heart of our legal system. If we can agree on this common set of facts as our starting place and agree to follow the facts and the law where they take us, I believe we can make a great deal of progress in this hearing today. I thank the panel for being here today, and I look forward to your testimony. Before we proceed further, I want to note for the record that the gentle lady from Pennsylvania, Ms. Dean, is unable to be with us today due to a death in the family. She very much wanted to participate in today's hearing, and I did not want anyone to misinterpret her absence. It is now my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman, and I appreciate especially the last, and I would extend my prayers and thoughts to Ms. Dean as well. I'm just a little under a year. In fact, Monday this week will be 1 year from losing my mother, so it is, for all of us, we go through that, and it's an expression of love. However, I will come to this hearing today and say that we are continuing. I appreciate the chairman's understanding. I appreciate the chairman outlining a great deal of the basic conclusion that was an affirmative conclusion from the Mueller investigation. That was the foreign interference and the Russian part of this. What is amazing, though, and I agree with the chairman's assessment of being attacked, and that's something we've known. The Russians were always a part. For some of us, we've been talking about the Russians for a long time in that. But it's about priorities. And here's my question about priorities and coming to this hearing. And the question of priorities is if we were attacked, as the chairman just said, then the priority should be to go to the battlefield on the attack where we were attacked on and not run by the sideshow to hear from the commentators. We should actually go to the one that Mr. Mueller actually said was, we have a problem here. We're showing you we've actually introduced indictments here. How can we firm up our elections? How can we do away with foreign interference? How can we do that? It's about priorities. And I think what has happened here is the chairman is showing the priorities. The priorities were from November 2016, it appears that we have an issue with who got elected president. And we thought the Mueller investigation would solve this for us, and it really did not, even after a lot of discussion. We're going to hear a lot about that today and the discussion that we have. But it goes back to priorities, and priorities of bringing what we focus on and how we focus on it. And if you look at the witnesses today and you discuss what was actually just went on for a while, we're not bringing Russia front and center. We're not bringing the threats to our election front and center, although I appreciate the chairman reading the letters that I send him and understanding what we could actually be working on. And I'm wanting to move forward there. But however, here we come with some folks that are great folks. You're wonderful on TV. I could catch your testimony on TV. In fact, by the way, I could this morning. I'm a Republican. I believe that you use everything that you've got to as much business as you want and generate as much as you want to work for yourself. But I don't believe it's the problem of this committee to have to come and hear from those who are not a part of the Mueller investigation, who are not a part of this, pontificating on things that you can do on TV like all of us get a chance to do occasionally, but not here on the hearing. But then we get, and I'm sort of reminded of the Russia priority issue because just a few years ago it was brought up and one of our candidates talked about Russia being a threat, and the former president, Mr. Obama, said, that the 80s are asking for their foreign policy back. Well, guess what? This committee is now hearing from the 70s, and they want their star witness back. In fact, it's very difficult for one of the witnesses here today, for many of us who could actually trace the distrust in government back to the witness here today, the 70 star of obstruction. In fact, I'll take it a little bit further. For those of us who've been looking into this for a while and wondering how we got started here, and for those of us who've heard me discuss the fact, and many on our committee and on our side discuss the fact of the corrupt cabal, what we see of Strzok, Page, McCabe, Comey, and others, how we actually got started here, I believe that they have the Godfather here today, Mr. Dean. In fact, they probably had a picture of how do we actually use the governmental resources to interfere in other people's campaigns. Mr. Dean is the Godfather. They may even had a picture of you, knowing how you do it. And that is here today, again, to talk about a president that obviously you don't like, an interview in ways that you had pled guilty to. I appreciate your right to be here, and I appreciate your right to share it anywhere else, but don't appreciate the fact that here we are again with priorities in this committee turned upside down. It is interesting to me, and I applaud the chairman for finally getting accommodation process from the Department of Justice that he could have had a long time ago. I'm glad we got it there. Now maybe we can move forward. Maybe we can begin to put this committee in order. But I would just go back and just say that I would ask my chairman on who we do agree on some things. Hopefully tomorrow we're actually going to have a bill we agree on, the 9/11 bill. But while we continue this part, asking opinions from commentators, promoting their agendas, my question is this. At the end of the day, for these not here, they're here commenting on a report, I go back to what the chairman asked, and he said, well, we may get there. And I said it was, we hope, I think was the exact words just a moment ago, to have Robert Mueller. Hope. This committee is obsessed with a document in which they could talk to the author, and we seem to not want to go there. We're hot and heavy to get everybody else here, but we don't want to go there. Because at the end of the day, the Mueller document, even despite his standing up and statements, stated there was no collusion, which is where it started. Where it started, there was that contact, and there was no charged obstruction. But here we are again today. Here we are looking at it as we go forward. Why? Because there is an obsession. There's another election around the corner. And that other election is simply being played out here. How can we damage the president? Because we don't like the cards that we got to run for re-election on with the economy and other things happening. So, Mr. Chairman, we're here again. I believe the priorities are wrong, but you've called the priorities. So now let the show begin. I yield back.
Thank you, Mr. Collins. I will now introduce today's witnesses. John Dean was the White House counsel under President Richard Nixon. He is most well known for his role as a principal witness during the Senate Watergate hearings, where his testimony was later fully corroborated as to its truthfulness by the revelations in President Nixon's White House tapes. Prior to his time in the White House, Mr. Dean served as the Republican chief counsel of this committee, as well as the associate director of the National Commission on Reform of Federal Criminal Laws. He has a BA from the College of Worcester, and he received his JD from the Georgetown University Law Center. Joyce White Vance served as the U.S. Attorney for the Northern District of Alabama from 2009 to 2017. She also served on the Attorney General's Advisory Committee and was the co-chair of its Criminal Practice Subcommittee. She is currently a distinguished professor of the practice of law at the University of Alabama School of Law. Ms. Vance received her bachelor's degree from Bates College and a JD from the University of Virginia Law School. John Malcolm is the vice president for the Institute for Constitutional Government and director of the Meese Center for Legal and Judicial Studies at the Heritage Foundation. He also serves as chairman of the Federalist Society's Criminal Law Practice Group. From 2001 to 2004, Mr. Malcolm served as a Deputy Assistant Attorney General in the Department of Justice. He received his bachelor's degree from Columbia College, my alma mater, and a JD from Harvard Law School. Barbara McCade served as the U.S. Attorney for the Eastern District of Michigan from 2010 to 2017. She also served as Vice Chair of the Attorney General's Advisory Committee and co-chaired its Terrorism and National Security subcommittees. She is currently a professor from practice at the University of Michigan Law School. Ms. McQuaid received her bachelor's degree from the University of Michigan and her JD at the University of Michigan Law School. We welcome our distinguished witnesses, and we thank you for participating in today's hearing. Now, if you would please rise, I will begin by swearing you in. You raise your right hands. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record show that the witnesses answered in the affirmative. Thank you, and you please be seated. Please note that your written statements will be entered into the record in their entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, there's a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. I will be a little loose in interpreting that 5 minutes for the witnesses, not necessarily for the members. Mr. Dean, you may begin.
Chairman Nadler, excuse me, Ranking Member Collins. The last time I appeared before your committee was July 11, 1974, during the impeachment inquiry of Richard Nixon. Clearly, I'm not here today as a fact witness. I accepted the invitation to come here today because I hope I can give a little historical perspective on the Mueller report. In many ways, the Mueller report is to President Trump what the so-called Watergate Roadmap, officially titled the Grand Jury Report and Recommendation Concerning Transmission of Evidence to the House of Representatives, was to President Richard Nixon. Stated a little differently, Special Counsel Mueller has provided this committee with a roadmap. Drawing from my testimony, I'd like to offer a few, actually just one I'm going to focus on, parallels I find with the Mueller report. I've laid out in my prepared statement 6 examples. Those examples are illustrative rather than exhaustive. But let me turn to the 6th, and anybody who has any question about the prior 5, I'm happy to address. The 6th is the Mueller report's effort regarding the influence of witnesses with pardons. As the citation shows, it's spread out throughout the report. Mr. Mueller addresses the question of whether President Trump dangled pardons or offered favorable treatment to Michael Cohen, Paul Manafort, Michael Cohen, and Roger Stone, whose name is actually redacted, but based on educated conjecture, I think that's pretty clear who it is. And the question is whether, in return for their pardons, they agreed to, or the suggestion of a pardon, he was seeking them to keep their silence, and how they coordinated with investigators. But also the Mueller report offers a very powerful legal analysis that, notwithstanding the fact that the pardon power is one of the most unrestricted presidential powers, it cannot be used for improper purposes. And I give the cite of that argument. What's interesting is Richard Nixon, who used the pardon in a similar way, recognized that it was improper. For example, in December of 1972, Chuck Colson went in to see the president to get a pardon, a commitment for Howard Hunt, who he had been responsible in bringing into the White House and whose wife had recently died in a crash and felt he couldn't withstand a trial and didn't want to spend the rest of his life in jail, so he was seeking a pardon assurance from Chuck Colson. The president reluctantly agreed to do that. And when Hunt was given the word, the so-called Cuban Americans who were part of the Watergate operation, they also took their cue from Hunt and pled. In my March 21st conversation with Nixon, we got into the subjects of pardons, and he at that point said he very clearly understood to grant pardons it would be wrong. I cite the actual exchange from that conversation. There's one that I did not cite in here is I learned in a later tape that Ehrlichman had been asked by the president to offer me a pardon to protect me and hopefully encourage me from not breaking rank. Ehrlichman knew that was wrong, so he didn't offer that pardon. In one of my last conversations with Richard Nixon, he told me in a very peculiar manner, getting up from his desk in the EOB office and going across the office and in a stage whisper saying to me, "John, I made a mistake in talking to Colson about clemency for Hunt, didn't I?" And I said, "Yes, Mr. President, that was probably obstruction of justice." When Haldeman and Ehrlichman were departing, they pled with the White House that they be given pardons. I think because Nixon knew he could only compound his situation at that point, that he refused to even entertain the request. Finally, let me close on the note, and I explain this at some length, that I certainly hope Don McGahn is a key witness before this committee. Because of my testimony, the model code of the ABA today makes very clear in Rule 1.13 that Mr. McGahn represents not Donald Trump, but the office of the president. His client is the office of the president, and I think he owes that office his testimony before this committee. Thank you.
Thank you, Professor Vance.
Good afternoon, Chairman Nadler, Ranking Member Collins, and members of the committee. Oh, am I not in it?
Press the little button, too.
Better? I'll start over. Good afternoon, Chairman Nadler, Ranking Member Collins, and members of the committee. Thank you for calling this hearing and for giving me the opportunity to testify and answer your questions. Let me cut right to the chase because I am a law professor, and so I'll start with some basic legal context. The federal principles of prosecution direct prosecutors to indict a case only if they believe they can obtain and sustain a conviction. That means obtain a conviction at trial, sustain it on appeal. The Mueller report sets out the 3 elements prosecutors have to be able to prove for each charge of obstruction of justice they would potentially bring: an obstructive act, a nexus between that act and an official proceeding, and a corrupt intent. So those are the 3 elements prosecutors would have to be able to prove beyond a reasonable doubt at trial. Because the special counsel followed DOJ policy and guidance in memos issued by the Office of Legal Counsel that prohibit indicting a sitting president, the report analyzed the evidence it contained without making an ultimate decision as to whether the evidence was sufficient to indict. Now, people can debate the merits of that position that's taken by the Office of Legal Counsel in the memo, but as long as that memo is in effect, it binds DOJ lawyers, and Robert Mueller, in his consideration, committed to following the law. I've reviewed Volume 2 of the Special Counsel's report, which lays out the evidence collected while investigating 10 potential instances of obstruction of justice. And based on my years of experience as a prosecutor, if I was assessing that evidence as to a person other than a sitting president who's covered by the OLC memo, the facts contained in that report would be sufficient to prove all of the elements necessary to charge multiple counts of obstruction of justice. The evidence is not equivocal, nor is the charging decision a close call. And I would be willing to personally indict the case and to try the case. I would have confidence that the evidence would be sufficient to obtain a guilty verdict and to win on appeal. Here's what I see as a prosecutor reading this report. There was an attack by a foreign country on our country and on our elections, and on multiple occasions the president tried to thwart it, curtail it, or end it completely, either by removing Mueller outright or by interfering with his ability to gather evidence. Here are some examples of the president's behavior documented by witness testimony and evidence collected by the special counsel. In the middle of the investigation, the president ordered his White House counsel to fire the special counsel. When that effort to fire the counsel became the subject of news reports, the president asked his White House counsel to lie about it and to create a false record to back up the lie. When the White House counsel declined to carry out his orders, the president moved outside of government, asking his former campaign manager to get the attorney general to unrecuse and to restrict the investigation to interference in future elections. In other words, no investigation into the president's conduct, the conduct of his associates, or the conduct of Russia in attacking our elections. When the president's campaign manager refused to carry out this order, the president began to pressure the attorney general personally, telling him in the Oval Office that he would be a hero if he unrecused himself, and making clear at the same time that he would be fired if he didn't carry out the president's demands. And he was ultimately fired. The president pressured multiple aides, including General Flynn, Manafort, and Cohen, not to cooperate with the investigation. He dangled the possibility of pardons if they didn't cooperate with the investigation. The president's personal counsel told his former campaign manager, Manafort, that he would be taken care of if he sat tight and refused to cooperate. This is some of what I see in the report. Based on my experience of more than 25 years as a federal prosecutor, I support the conclusion that more than 1,000 of my former colleagues came to, and that I co-signed in a public statement last month, saying that if anyone other than a president of the United States committed this conduct, he would be under indictment today for multiple acts of obstruction of justice. The Mueller report has an extensive discussion, a layout, a legal analysis about why a president is not above the law. This theory that we've discussed about a unitary executive and the scope of presidential power. But you don't have to be a legal expert to understand that in this country, no one is above the law. If you or I had committed this same conduct, we would have been charged by now. So the task before this committee in Congress is not an easy one. It doesn't bring me any pleasure to have to discuss these facts. I suspect it does not bring you pleasure to have to consider them, but I am honored and sobered to have this opportunity to contribute to your work, and I hope I can be helpful in answering any questions that you have. Thank you very much, Mr. Chairman.
Thank you, Mr. Malcolm.
Chairman Nadler, Ranking Member Collins, and distinguished members of Congress. I'm the Vice President of the Institute for Constitutional Government at the Heritage Foundation. I've also served as a Deputy Assistant Attorney General, an Assistant United States Attorney, an Associate Independent Counsel, and as a criminal defense attorney. Special Counsel Mueller deserves a lot of credit for conducting a thorough investigation. While Volume 1 of his report chronicles in detail how the Russians attempted to interfere in our election and concludes that no one in the Trump campaign was involved in that unlawful effort, I am less enthusiastic about Volume 2. Under the applicable regulations, it was the special counsel's duty to provide the Attorney General with a confidential report explaining the prosecution or declination decisions reached by him. By not making a traditional prosecutorial judgment with respect to the obstruction of justice allegations, Mr. Mueller failed to fulfill that duty. While governing OLC opinions provide that a sitting president cannot be indicted, there was nothing to preclude the special counsel from stating that the evidence would be sufficient to convict the president of obstruction of justice if that's what he believed. By not doing so, the special counsel put the Attorney General in the difficult situation of having to make that decision. Here, General Barr's determination that the evidence is insufficient to establish that the president attempted to obstruct justice is eminently reasonable. While it is possible for someone to obstruct justice who did not commit the offense that is under investigation, it is extremely rare. In the overwhelming majority of cases, individuals who attempt to obstruct justice do so because they know darn well that they committed a crime and fear that the investigation will uncover that fact. Moreover, it is almost invariably the case that someone attempting to obstruct an investigation also engages in other nefarious activities, such as destroying evidence, suborning perjury, bribing witnesses, or threatening them with bodily harm. Here, the president provided over 1 million pages of documents, allowed key members of his staff to be interviewed, and submitted written questions or answers to questions. These are not the actions of someone attempting to obstruct an ongoing investigation, despite being clearly maddened by its existence. In obstruction of justice cases, the most difficult thing to establish is that the accused acted with a corrupt intent, that is, for an illegitimate purpose. When someone destroys evidence or threatens witnesses, this task is relatively straightforward. Not so here. The president had perfectly legitimate reasons to be exasperated by the cloud hanging over his presidency from this investigation and for wishing it to come to a speedy conclusion. The investigation caused some to question the legitimacy of his election because the allegations involve claims that high-level people in his campaign engaged in a conspiracy with Russia to steal the election. The president repeatedly expressed concerns that the investigation was hampering his ability to govern and to engage in foreign relations, especially with Russia. President Trump might well have concluded that the investigation should be curtailed or even terminated because it was impeding his ability to do the job that the American people elected him to do. Such an alternative, non-corrupt motive, rather than naked self-interest, might also explain his conduct. Further, adopting Mueller's legal theory could have a chilling effect on a president who might well hesitate before engaging in some controversial action, such as removing an official, signing an executive order, or issuing a pardon, out of fear that his subjective intent might be questioned at some point in the future by a prosecutor, perhaps a politically motivated one, undertaking a criminal investigation. For this reason, the law requires that Congress issue a clear statement before a generally worded statute, such as the one that Mr. Mueller relied upon, can be applied to the president. No such clear statement exists here. To be sure, OLC has stated that some statutes, such as the bribery statute, can be applied to the president. However, while it is easy to disentangle facially criminal acts, such as paying a bribe or threatening a witness, from legitimate exercises of presidential authority, The same cannot be said of many of the acts that were investigated by the special counsel, such as criticizing the fairness of the investigation, asking subordinates to publicly defend him, removing an official, or contemplating issuing a pardon, each of which may have been undertaken for a mixed motive or an entirely pure one. Deciding which is which would inevitably interfere with the president's ability to serve the nation as he sees fit in the exercise of his Article II powers, thereby raising profound separation of powers issues. While it is certainly true that no man, including the President of the United States, is above the law, it is equally true that the President occupies a unique position in our constitutional structure, and that some laws apply differently to him and some don't apply at all, at least when there has been no clear statement by Congress that the law should apply to him, or when doing so might impinge upon the exercise of his constitutional prerogatives. I thank you for inviting me here to testify today, and I look forward to answering any questions you might have.
Thank you very much, Professor McQuaid.
Thank you, Chairman Nadler, Ranking Member Collins, and distinguished members of this committee. I am honored to be here today, and thank you for the opportunity to talk with you about obstruction of justice. I've read the special counsel's report, and to me, the most significant finding in that report is that Russia interfered with our election in sweeping and systematic fashion. And through that lens, I will share two observations. First, about what happened, and second, about why that matters. First, the conduct described in the report constitutes multiple crimes of obstruction of justice. It's supported by evidence of guilt beyond a reasonable doubt, and I'm confident that if anyone other than a sitting president committed this conduct, that person would be charged with crimes. Second, why does that matter? Well, the obstruction described in the report created a risk to our national security. It was designed to prevent investigators from learning all of the facts about an attack on our country by a hostile foreign adversary. Let me explain each of those observations briefly. First, what happened? The special counsel's report describes 10 episodes of potential obstruction of justice. And with regard to 4 of those episodes, the special counsel found substantial evidence for all 3 elements of obstruction of justice. Those obstruction crimes include requesting that White House counsel Don McGahn remove Robert Mueller as special counsel, asking Don McGahn to falsely deny public reports about that order and to create a false document to support that lie. It includes reports of efforts to persuade Attorney General Jeff Sessions to reverse his recusal decision, which would have been unethical, and to publicly announce that the Russia investigation would focus on future elections only. It also talks about efforts to influence the testimony of Paul Manafort, a former campaign chairman. Let me focus on just one of those incidents, and that's the incident where the report describes persistent efforts to curtail the special counsel's investigation by directing Attorney General Sessions to reverse his recusal decision and to limit the investigation to future elections. President Trump asked various intermediaries, including Corey Lewandowski, who was at that point a private citizen, to convey a message to Mr. Sessions, but ultimately none of them did it. But for the acts of those associates, Mr. Trump would have limited the investigation to future elections. That would have prevented Mr. Mueller from learning the facts about Russian interference in the 2016 election, essential to our national security. And although Mr. Mueller's investigation did not establish the crime of conspiracy against the Trump campaign under federal statutes, proof of underlying crime is not required to prove obstruction. And there's a very important reason for that. That's because it's the interference in the quest for the truth that the law prohibits. And let's not forget that the investigation did establish sufficient facts to charge 37 defendants with crimes, including Russian intelligence officials. And that's despite the fact that some people, including the president, refused to talk to Mr. Mueller. The report says that some people lied to the special counsel, some deleted communications, and some used encrypted applications to conceal their conversations. As the report says, given these gaps, the office cannot rule out the possibility that unavailable information would shed additional light. This body has the power to obtain additional information. The report identified possible motives, including personal embarrassment, the possibility that his conduct amounted to crimes, and the legitimacy of his election. And second, why it matters. If Mr. Trump had been successful in limiting the scope of the investigation to future elections, that would have harmed our national security by shielding Russia's conduct in attacking the 2016 election. But for the conduct of other individuals, Mr. Trump would have thwarted Mr. Mueller's efforts. By seeking to curtail the investigation, President Trump committed an act that threatened the national security of this country. As Robert Mueller concluded in his report, he reiterated that the central allegation of our indictments were that multiple and systematic efforts to interfere with our election occurred. That allegation deserves the attention of every American. I hope to answer your questions to give that allegation the attention that it deserves. Thank you.
Thank you very much. We will now proceed under the 5-minute rule with questions. I will begin by recognizing myself for 5 minutes. Mr. Dean, as you're no doubt aware, the committee subpoenaed former White House counsel Don McGahn to produce White House documents shared with him and his counsel over the course of the special counsel's investigation and to testify before the committee on May 21st. At the direction of the White House, Mr. McGahn has not produced any documents. Additionally, the White House, while it has not formally invoked executive privilege over any specific information Mr. McGahn's testimony may cover, has nonetheless instructed him not to appear at all merely because it may implicate the privilege. Do you agree with the White House, or does Mr. McGahn still have a legal obligation to appear before the committee? And if so, why?
I have also read the OLC opinion of May 20th that says that a White House employee or a former White House employee has total immunity from testifying or appearing before Congress. That pushes the outer limit further than I have ever seen it pushed. And while they cite me in that memo, for 2 memos I received, both of those instances, the witness did appear. The Flanagan memo, for example, it was arranged that he would come to Congress. In other instances, when Henry Kissinger was asked to appear, we found a middle ground to have a meeting in Blair House. So there are solutions to this if the parties want to cooperate. So I think this is a smokescreen at this point, and I hope that the committee will pierce it because I think it's important.
Thank you. Professor McQuaid, on page 1 of volume 2 of the Mueller report, the special counsel described the legal and policy considerations that guided his investigation. The special counsel begins by noting that his team determined not to make a traditional prosecutorial judgment and that his office accepted the Department of Justice OLC conclusion, which states that an indictment of a sitting president would, quote, impermissibly undermine the capacity of the executive branch to perform its constitutionally assigned functions, close quote. The special counsel, however, made clear as well that a federal indictment of a sitting president would also potentially preempt constitutional processes for addressing presidential misconduct and specifically referenced Article 1, Congress's Article 1 powers. What do you make of Special Counsel Mueller's reference here to Congress's separate authority?
I think that what Mr. Mueller was doing there was being incredibly deferential because he was bound by the Office of Legal Counsel opinion that said he could not indict a sitting president. He thought it would be improper to even make an accusation that would disparage President Trump because he did not want to step on the powers of Congress, which alone has the power of impeachment.
So do you agree that with the special counsel that Congress has an independent duty to investigate possible misconduct or malfeasance by executive branch officials, including the president, even if that's a do-over of the Mueller report?
Yes, I do, and I don't know that I would even call it a do-over. I think it's a separate inquiry that this body has a responsibility to conduct.
Thank you. Now, returning to the Mueller report, the special counsel specifically notes that he pursued his obstruction of justice investigation in order to preserve evidence and protect the integrity of future investigations. The special counsel's report states, quote, while the OLC opinion concludes that a sitting president may not be prosecuted, it recognizes that a criminal investigation during the president's term is permissible. The OLC opinion also recognizes that a president does not have immunity after he leaves office. And if individuals other than the president committed an obstruction offense, they may be prosecuted at this time. Given those considerations, the facts known to us and the strong public interest in safeguarding the integrity of the criminal justice system, We conducted a thorough factual investigation in order to preserve the evidence when memories were fresh and documentary materials were available." Close quote. Now, Ms. Vance, Professor Vance, what is your reaction to the special counsel's inclusion of this language in the report?
This language, I think, explains what we all know to be true. There has been a little bit of complaint that Special Counsel Mueller, once he realized he couldn't indict a sitting president, should not have continued to investigate. This language indicates that that's not the case. It was important to investigate while memories were fresh and evidence could be obtained. And that's because a president is not immune for all time from prosecution, only while he's in office. So Mueller could have been investigating for future prosecutors when the president was no longer in office. He could have been investigating information about other people other than the president who might have participated in crimes. There were abundant reasons for this investigation to continue, this investigation into the criminal justice implications of the president's conduct.
Thank you. Finally, Ms. McQuaid, the Mueller report also acknowledges that Congress has the authority to prohibit a president's corrupt use of his authority in order to protect the integrity of the administration of justice. The special counsel further observed that under applicable Supreme Court precedent, the Constitution does not categorically and permanently immunize a president for obstructing justice through the use of his Article II powers. The separation of powers doctrine authorizes Congress to protect official proceedings, including those of courts and grand juries, from corrupt, obstructive acts, regardless of their source, unquote. As such, the special counsel concluded that, quote, Congress may apply the obstruction laws to the president's corrupt exercise of the powers of office. Congress may apply the obstruction laws to the president's corrupt exercise of the powers of office, accords with our constitutional system of checks and balances and the principle that no person is above the law. Do you agree with the special counsel's conclusion that the Constitution permits Congress to prohibit a president's corrupt exercise of the powers of his or her office, and if so, why?
Yes, Chairman. There is an extensive section in Robert Mueller's report that talks about that. It addresses that theory that was first advanced by William Barr in the 19-page memo that he submitted to Congress last summer, taking the view that Congress cannot limit the president because of separation of powers. But I think the ultimate conclusion is that the president does not have just the power to execute the laws, but the Constitution requires that he faithfully execute the laws. And that means that he cannot act corruptly. He must always act in the best interest of the country. And so, yes, I do agree on that theory.
Thank you. My time has expired. I'll now recognize the ranking member, the gentleman from Georgia, Mr. Collins.
Thank you, Mr. Chairman. Interesting last comment there. We may get back to that as this issue of faithful and how that actually turns out. But I do want to go back to something that you and Ms. Professor Vance have both talked about, and it's this issue of did Mueller investigation, did they were going to charge or not charge based on OLC opinion. It's an interesting concept, especially when you go back to not was the final charge from Mueller, but then to Bill Barr himself when actually giving the report the ultimate charging authority here. And it said in the letter, the first letter that came from the Attorney General, it said, after reviewing the special counsel's final report on these issues, consulting with department officials, including Office of Legal Counsel, and applying the principles of federal prosecution that guide our charging decision, the Deputy Attorney General, Rod Rosenstein, and I have concluded that the evidence developed during the special counsel investigation is not sufficient to establish that the president committed an obstruction of justice offense. Our determination was made without regard to or based upon any limitations based from these considerations surrounding the indictment. Interesting, this has been discussed later on because it became after the discussion, there was a joint statement put out by the Attorney General's office and by the special counsel office that said this: the Attorney General has previously stated that the special counsel repeatedly affirmed that he was not saying that but for the OLC opinion, he would have found the president obstructed justice. The special counsel's report and his statement today made clear that the office concluded that it would not reach a determination one way or the other about whether the president committed a crime. And there's no conflict between these statements. So I think the interesting part that is coming along here is this discussion on the fact that it does appear, and you can take one part saying he was bound by this and you can go on that, but the Attorney General made it very clear that when he looked at it and it was up to him if he wanted to move forward with charge, he chose not to charge because Mueller had gave it to him and took into account the special counsel determination, and then later on with the special counsel himself saying that he wasn't going to charge either way and was not bound by this opinion. My question becomes, though, you've got great opinions, both of you, on these issues of obstruction, but again, as I said before in starting this, the main priority, and you both mentioned this, was the Russian interference in our elections. Ms. McQuaid, I have a quote, and it was a tweet from you. It says, "Hey, Mueller, look over here. At Maddow has found the collusion. Follow the sanctions. If this whole cable news thing doesn't work out for you, Rachel, you have a real future in the FBI." This was December 1, 2018. I have a question. Do you, yes or no, do you and Rachel Maddow have evidence of collusion that the special counsel didn't have?
Well, you know, collusion is an interesting term, Congressman Collins, and it's a term that Robert Mueller in his report says I didn't use because it's kind of confusing. And so ultimately, after reading his report, what he says is, I wasn't able to establish the crime of conspiracy, but he did document numerous contacts between Russia and the Trump campaign. In fact, right at the very beginning of the report, at page 1.
And Ms. McCabe, I want to jump in here because I agree you can read the report. The interesting, you just made an interesting comment, though, in which many of us have said about this issue of collusion, which there was not. But I've had many, even members of Congress and others, continue this private, that there is collusion in plain sight. The president's committed a crime. And when you just stated the original process here, but my question is, and I'm assuming it's a no, you don't have any more information or evidence than we have here. John Dean, just to...
I'm sorry, is that a question? May I answer?
No, that was... Got a minute and 57. I'm bound by the 5 minute.
I'll refer to page 1 of the report.
And I've read it. Mr. Dean, interesting. You talked about the issue of pardon, but actually in the Mueller report itself, when it talked about the pardon, and you discussed it where Nixon said he shouldn't have, the actual quote on page 122 of this was, "I don't want to talk about pardons for Flynn yet." In fact, the president actually said, he never offered a pardon. He didn't want to talk about it. So again, here's our issue here, and you made the best of all the concerning of this right now. When you start off saying, "I'm not a fact witness." Neither are others. We're simply here conjecturing opinions in law school, and for those of us writing notes feverishly, I feel like, Professor, we're back in law school again. But at the end of the day, where we're headed with this is the concern that I have is that we have, going back, and the discussion was here for later on, what does this committee have that Robert Mueller didn't have? What does this committee have when you go through the literally 19 lawyers, 40 FBI agents, 2,800 subpoenas, 500, we barely can get through most of our work week without stopping up. So I think the question and concern for most of us here is, this is not a redo, as the chairman, it is a redo from a weaker position, and simply goes back to what has always been said here. This is a political consideration, not a criminal. We're not an investigator. There's plenty more that I would like to have answered here. We just unfortunately are bound by our times on this, and with that, I'll have to yield back to the chairman.
Mr. Chairman, may I?
The time has expired. The witness may answer the question.
Yeah, the question was addressed to me, and I think that this committee does have a role, and it is adding something that the special counsel could not, and that's public education. This report has not been widely read in the United States. It's not even been widely read in the Congress from some of my conversations. But I think it's a very important function that the committee is serving by bringing these matters to public attention.
I appreciate that, and for the educational purposes, I really meant it more as a statement and not a question.
The gentleman's time is now expired. The gentlelady from California, Ms. Lofgren, is recognized for 5 minutes.
Thank you, Mr. Chairman. On May 17, 2017, Deputy Attorney General Rosenstein appointed the special counsel, and on page 8 of Volume 2 of the report, it states, and I quote, "In the days following the special counsel's appointment, the president repeatedly told advisors, including Priebus, Bannon, and McGahn, that special counsel Mueller had conflicts of interest." On page 81, the report states, and again I quote, "Bannon recalled telling the president that the reported conflicts were ridiculous and that none of them was real or could come close to justifying precluding Mueller from serving as special counsel." On May 23rd, the Justice Department cleared the special counsel of any conflicts. On page 81 of Volume 2, it describes the president's reaction, quote, "The president complained about the asserted conflicts and prodded McGahn to reach out to Rosenstein about the issue. McGahn said he responded that he could not make such a call, and the president should instead consult his personal lawyer because it was not a White House issue. Mr. Dean, you recall that you were here last, July 11th, 1974. I was here too, working for my predecessor, Don Edwards, who was a member of the judiciary at this time. You have extensive experience as the counsel for the White House. Understanding the role of White House counsel, why would McCann refer the president to private counsel?
Because what's happened since my day in the White House is the American Bar Association developed a rule, Rule 1.13, which makes it very clear in representation of an organization that the client are not the constituents of the organization or the person who runs the organization or people who run the organization. It is the organization. As a result, Mr. McCann represents not Donald Trump, but he represents the office of the president. So he has a very different client. He also, apparently from press reports, has advised the president that he has no attorney-client privilege. So that's why I would assume is the reason he referred the president to outside counsel to deal with these issues.
Thank you. The report goes on to cite contemporaneous notes taken by Mr. McGahn on May 23rd on pages 81 and 82 of Volume 2. It says, quote, McGahn advised that the president could discuss the issue with his personal attorney, but it would look like still trying to meddle in the investigation, and knocking out Mueller would be another fact used to claim obstruction of justice. Professor Vance, what is your reaction to this exchange between the president and the White House counsel?
This entire set of facts, Congresswoman, is very troubling because remember where we are at this point in time. We have a special counsel who's just been appointed to investigate Russian interference with the election, and now suddenly we have a president who's looking for reasons to remove him. And the reason that the president lands on is, well, this special counsel has some conflicts. He shouldn't be permitted to run an investigation into me. He engaged in some representation with some other lawyers who represented me. We once had a squabble about a golf course. There were a couple of issues that the president raised, and those issues were examined by the Justice Department, and the Justice Department cleared special counsel Mueller. So there has never been legally a conflict with special counsel Mueller's participation in this case. But the president persisted here, and as you've discussed with Mr. Dean, that was referred on to the president as a matter he should take up with his personal lawyer, not to continue discussing with the White House counsel. And this repeated fallback to the president by the notion that he should be able to somehow conflict the special counsel out of his job was receiving strong pushback. So the president's continued persistence here, at least in my judgment, forms one of the acts of obstruction, ultimately resulting in the president taking affirmative steps to have special counsel Mueller fired. But this entire colloquy that you refer to is very instructive on the issue of the president's intent at this point in time.
Thank you, Professor. Professor McQuaid, do you see it similarly? What's your reaction to this?
It is, and I think one of the things that's important, I know the report is long at 448 pages, but it really is important to read the whole report, and I would urge everyone here to do so if they have not yet had an opportunity, and members of the public, because even though only a handful of the obstructive acts were found to have met each and every element of obstruction of justice, I think it's really important to see the whole context of behavior to understand the significance of those events. If this were a criminal case in court, a jury would be instructed to look at the totality of the circumstances so that they can have a full understanding of what's going on. And it seemed that what's going on here, looking at the totality of the circumstances, is that President Trump felt threatened by Robert Mueller. He felt threatened by him even though there was no ultimate finding of a crime of conspiracy. At the time the investigation was going on, President Trump didn't know that was going to be the outcome. In fact, he was aware of numerous contacts with Russia that may be exposed, the Trump Tower meeting with Russians and his family members. There was also the matter of Michael Cohen's payments to a woman by her silence before the election. All of those things could have been things that motivated President Trump. Let's not forget that one of the things that motivated Bill Clinton was covering up an extramarital affair. And so there are things other than the crime that the investigator is looking at that could motivate a person to try to end an investigation. And under the law, they are equally prohibited.
My time has expired.
I thank the gentlelady. The gentleman from Ohio, Mr. Shabbat.
Thank you, Mr. Chairman. Mr. Dean, it's, to the best of my knowledge, I don't think that we've ever met. I'm one of 435 members of the House. There are a lot of us, but only one of you, and you're pretty famous. Let me take you back a ways. Back in 1972, I was a freshman in college, and I voted for the president for the first time. I'd have been 19 years old. I voted for Richard Nixon, principally because I thought he was improving relations with Russia and with China, and I thought that was a good thing. Well, the next year, 1973, in June 22nd to be exact, I married my high school sweetheart. Next week, we'll have been married 46 years now. And on our honeymoon in Gatlinburg, Tennessee, and then in Mammoth Cave, Kentucky, among other things that I remember watching you testify before Congress about the president that I had voted for and about some very bad things that he had done. The next year, of course, that president resigned in disgrace and was replaced by Gerald Ford. A lot of my friends, people my age at the time, were really turned off from politics, thought they were a bunch of crooks. Why would anybody ever want to be involved in politics? It had just the opposite effect on me. I thought we needed people involved in politics for the right reason, that want to help their community or the country. And so I decided that someday I was going to get involved in politics. And I voted for, a couple years later, 76, I voted for Jimmy Carter, by the way, for president, because I thought it was wrong that Ford had pardoned Nixon, figuring that there'd been some sort of crooked deal that went on there. So anyway, a couple years later, I did get involved in politics, and I ran as an independent for Cincinnati City Council. I lost. Then 2 years later, I ran as a Republican, and this time I lost again. So finally, I did get elected to council the next time, served for 5 years there, served for 5 years as a county commission, and then lo and behold, back in 1994, in the Republican Revolution, I got elected to Congress and got appointed to this committee that I wanted to be on. So 25 years after watching you on television relative to Nixon and Watergate, I was a member of the Judiciary Committee impeaching another president, this time William Jefferson Clinton, and I'm one of only two members in the House who were actually House impeachment managers in the Senate trial. Jim Sensenbrenner was the other. Now it's 20 years after that, and it's been alleged that another president did something wrong, that he allegedly colluded with the Russians to win an election. I thought the responsible thing to do was to reserve my judgment until the special counsel, this time Robert Mueller, it was an independent counsel back under Clinton, until the special counsel this time completed his report on the matter. He did, and he found no collusion. And he sort of punted on obstruction of justice, but the Attorney General determined no obstruction of justice. So, Mr. Dean, my question to you is this. Rather than reserve your judgment until the Mueller report came out, like I did, you were an outspoken critic of President Trump, and you alleged publicly on more than one occasion, even before the Mueller report came out, that you believed President Trump had colluded with the Russians. Isn't that true?
I don't think I quite said collusion. I think there is evidence, incidentally, in the report of collusion. There have been a number of well-done articles that draw on the different contacts between the Trump people and the Russians and make a fairly strong case for collusion.
I think you did say
Congressman,
collusion or colluded. Yeah.
I'd just like to correct you on one fact, that you couldn't have, in 1971, have been attracted to Nixon because of China, because he hadn't gone to China
I
yet.
voted in 72.
Right, by 72,
Yeah,
it was in the during the 72
Yeah.
campaign.
Right, that's what I mean, yes. Mr. Malcolm, let me go to you. It's my understanding that it's your view that President Trump neither colluded with the Russians nor obstructed justice. Is that correct?
Well, it's special counsel Mueller's conclusion on the former, and then on the latter, I don't think as a legal matter under the statute that Mueller relied upon, he could be convicted of obstruction of justice, and I thought the determination based on the facts was an eminently reasonable one that he did not engage in obstruction of justice.
Okay, and real quickly, when Attorney General Barr announced his determination on alleged obstruction of justice, was he within the scope of his authority to do so?
He was within the scope of his authority to do whatever he wanted. I thought that the regulations say that he was supposed to make a prosecution or declination decision, which he failed to do. But, he was given the authority to investigate these matters, and he did what he did in his report.
Thank you very much. My time's expired, Mr. Chairman.
Thank you. The gentlelady from Texas, Ms. Jackson Lee.
As I hold this book up, all that we say refers to this roadmap. On June 13, 2017, the acting Attorney General testified before Congress. There was no good cause to remove the special counsel. On June 14, 2017, the President issued a press statement stating he had no intention of firing Mueller. However, on the page 90 of Volume 2 of this report, the report says, quote, "But the next day the media reported that the President was under investigation for obstruction of justice, and the special counsel was interviewing witnesses about events related to possible obstruction, spurring the President to write critical tweets about the special counsel's investigation. The President called McGahn at home that night and then called him on Saturday from Camp David. Pages 85 to 87 of Volume 2 provide more details on the Saturday calls between the President and the White House counsel. Page 85 says on Saturday, June 17, 2017, the President called McGahn and directed him to have the special counsel removed. McGahn was at home and the President was at Camp David. In interviews with this office, McGahn recalled that the President called him at home twice and on both occasions directed him to call Rosenstein and say that Mueller had conflicts that precluded him from serving as special counsel. Page 85 provides further detail about the first call. Quote, "On the first call, McGahn recalled that the President said something like, 'You got to do this. You got to call Rod.' McGahn said he told the President that he would see what he could do. McGahn was perturbed by the call and did not intend to act on the request." Mr. Dean, speaking as a former White House counsel, why would that call from the President perturb McGahn?
Well, I think Mr. McGahn has stated that he was very aware that firing the special counsel could provoke an equivalent to the Nixon Saturday Night Massacre, which, while he wasn't old enough to have remembered it personally, he'd certainly read about it and knew the negative consequences that had flowed from it, and so he stepped away from it and didn't want any part of it.
Page 86 of Volume 2 of the report describes the second call, quote, "When the President called McGahn a second time to follow up on the order to call the Department of Justice, McGahn recalled that the President was more direct, saying something like, 'Call Rod, tell Rod that Mueller has conflicts and can't be the special counsel,' more direct. McGahn recalled the President saying, 'Mueller has to go, and call me back when you do it.' McGahn understood the President to be saying that the special counsel had to be removed by Rosenstein. What do you believe, or what is your reaction to this exchange, and would you find such behavior concerning?" Professor Vance, and then Professor McQuaid.
Yes, this conduct to me seems to have all the elements prosecutors would need to have to successfully charge obstruction of justice. There's an obstructive act, the effort to go ahead and have the special counsel fired. There's a nexus to an investigation. At this point, the President is aware that investigation is ongoing. And there appears to be a corrupt motive as well, curtailing the special counsel's investigation. So this entire series of conversations and conduct is deeply troubling.
Thank you, Professor McQuaid.
Yes, Congresswoman, I would agree with that. In fact, it prompted Don McGahn to believe he had to resign because he could not participate in something that would be akin to the Saturday Night Massacre in the firing of Robert Mueller. He understood the significance of it, the consequences, and that it would amount to a crime of obstruction of justice. And this idea that Robert Mueller was in any way conflicted really was frivolous, as officials advised him. It was based on the fact that President Trump said interviewed for the FBI job and didn't get it. That's not quite right. He came in and provided advice to the White House about what to look for in the next FBI director. And the squabble about a golf club membership was actually, Robert Mueller said, I work so hard that I'd never have time to play golf. Could I have a refund? I am going to resign from the club. And the Trump organization said no. That was the conflict of interest.
Page 78 of the report said, McGahn did not carry out the instruction for fear of being seen as triggering another Saturday night massacre, and instead prepared to resign. Page 85 and 86 provide a bit more context to McGahn's state of mind after receiving these phone calls. Quote, McGahn, once concerned about having any role in asking the acting attorney general to fire the special counsel because he had grown up in the Reagan era and wanted to be more like Judge Robert Bork and not Saturday Night Massacre Bork, McGahn considered the president's request to be an inflection point, and he wanted to hit the brakes. Very quickly, Mr. Dean, you mentioned it before, what was the Saturday Night Massacre?
I'm sorry, I missed the end of
What
it.
was the Saturday Night Massacre?
Saturday Night Massacre occurred in October of 1973 when Richard Nixon removed or fired Archibald Cox as the special counsel, the Watergate special prosecutor, because he exceeded what Nixon thought was his authority to demand tapes, the secret Nixon recordings. He had told him that they would offer them to a member of the Senate, John Stennis, who happened to have a very bad hearing problem, to validate the White House prepared transcripts, and the special counsel Cox rejected it. And Nixon asked the Attorney General to fire him, Mr. Richardson, who refused and resigned. He asked, in turn, Mr. Ruckelshaus, the Deputy Attorney General, to fire Cox. He, too, refused and resigned. It went to the third person in line of authority in the Department of Justice, to Mr. Bork, who did carry out the order.
Thank you.
Thank you. The gentlelady's time has expired. The gentleman from Texas, Mr. Gohmert.
Thank you, Mr. Chairman. It's unusual to have the majority fail to properly give the basis for expertise of one of its own witnesses. But, Mr. Dean, you've got a lot more qualifications in this area than they actually provided in the introduction. Back when New York Times was more accurate, they reported that in your case, John Sirica, the judge, read the formal charges regarding the conspiracy to thwart the investigation, and he read as follows, that you were suborning perjury, giving false statements and concealing evidence in the trial before Judge Sirica last winter of the men arrested in the break-in, offering clemency to the defendants, paying to keep the arrested men silent, asking the Federal Bureau of Investigation for information, attempting to get the CIA to provide money for the payments. In furtherance of the conspiracy, Judge Sirica continued reading. Dean had committed 6 specific overt acts on or about June 27, 72, he directed G. Gordon Liddy to tell Howard Hunt to leave the United States. He asked General Vernon Walters, the deputy director of the CIA, whether the CIA could use covert funds to pay the bail and salary of those involved in the Watergate break-in. He had asked the president's former private attorney, Herbert Kalmbach, to raise funds with which to make the payments to the Watergate defendants. He had met with Jeb Stuart Magruder on the campaign staff to help Magruder prepare false, deceptive, and misleading testimony to give the grand jury. He had asked John Caulfield to offer executive clemency to James McCord, another of the original defendants, and he had asked L. Patrick Gray, former acting director of the FBI, for reports of information gained in the investigation break-in. We've heard different reports from different people involved. Magruder ended up saying, after different versions, that you were the one that ordered the break-in of the Watergate headquarters, and I see you shaking your head, but did you ever order or convey an order to break into the Democratic headquarters at Watergate Hotel?
First of all, on your description of my pleading guilty.
Yeah, that came from the New York Times. You can take it up with them.
Right.
But did you ever order?
May I explain before I answer?
Well, You can
raised
either
that.
answer the question or not.
Be happy to answer your question.
Please.
The question is, did I ever
Did you order or
Yes,
ever convey the order to break into the Democratic headquarters?
No.
All right, thank you. And I know I wasn't.
In fact, I have no evidence that anybody at the White House
Look, I've only got
knew of
5
it.
minutes, and the
Okay.
chairman's not as liberal with us as he is with the Democrats. But for those who are not familiar with the statements here, in his last civil suit, Mr. Dean said, "It could be that I misspoke myself. It's either a misstatement or an incomplete transcription, highly possible. I just misspoke myself. We were trying to paint with the broadest brush we could. I may be not artfully stating here, maybe it was imposing hindsight on events. That is a less than accurate description," talking about what he had said previously. Obviously, it was a self-serving answer, so maybe I can help some of my colleagues if you're tempted to go after questions like that. But
I don't even know what you're referring to.
it was the last civil suit you were involved in with Mr. Liddy, where he had begged you to sue him because he called you the biggest liar in the world and things of that nature. And you finally sued him with a bunch of other people and ultimately dismissed the case against him without going to trial as he had asked you to do.
That is not
But
correct.
let me, there are similarities, you're right, with regard to Watergate. In both, an administration was seeking to illegally spy on another candidate, and both people were hired to attempt to gather evidence that could be used against a candidate. In Watergate, the committee to re-elect the president hired burglars to break into the DNC headquarters. In Watergate, administration officials tried to find ways to use federal dollars to pay for their criminal spying. In Russiagate, members of the federal government used the Intel, DOJ, and FBI communities to attempt to defeat a presidential candidate. Then when that failed, to have him removed from office. In Russiagate, the Clinton campaign and the FBI paid a foreign agent to collude with Russians to produce opposition research that turned out completely false, as the Mueller report indicated, that could be used to commit a fraud upon the FISA court and get multiple warrants to spy on opposition campaign. In Russiagate, it was the Clinton campaign through Fusion GPS in concert with the FBI, possibly intelligence, who hired people to do the spying. And what really bothers me, oh, and by the way, Professor White Vance, I have an amazing admiration. I used to tell people, if you ever talk to a lawyer that says, I'm going to win at court on this and I'll win the appeal, you run from them because they're either incompetent or they're corrupt. But you have such amazing ability. You know you could win at court on an appeal, so I'm in admiration. But let me tell you, the frauds that were committed on the FISA court in this matter and the abuses of American citizens' Fourth Amendment rights and the fact that people who once cared about this country's Fourth Amendment rights are now more concerned with taking out another party's president, making sure he doesn't get reelected, tells me that we are in a greater danger for our Constitution at this time than we were from the outside World War II. And I appreciate getting nearly 30 seconds short of what y'all did. Thank you.